expenditures by the Department of Corrections on certain correctional institution construction projects. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2215 amends KSA 7552-167. This is the section of statute that defines the terms related to the Secretary of Corrections being authorized to enter into these public-private partnerships with private entities for public-private purposes of funding new or renovated buildings at a correctional institution. Current law there in the definition of public-private partnership, it defines it as the relationship established between the Department of Corrections and a private entity by contracting for the performance of any combination of specified functions or responsibilities to develop, finance, construct, or renovate a building at a correctional institution where the Department of Corrections cost for development, finance, construction, or renovation of such building does not exceed 25% of the total cost of developing, financing, constructing, or renovating that building. This bill would amend that definition and increase that 25% to 50%, allowing the department costs not to exceed 50% of the total cost. And I can take any questions.
Thank you. Committee, any questions? Not seeing any, and thank you very much. We're going to first hear from proponent conferee Keith Bradshaw, Executive Director, Contracts and Finance, Kansas Department of Corrections. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Again, my name is Keith Bradshaw. I'm Executive Director of Contracts and Finance for the KDOC. I appreciate the opportunity to come here and testify in support of House Bill 2215. As Natalie explained, this is simply changing the matching rate for state funds from 25% to 50%, which would allow us to draw down and leverage private donations for the construction of a career campus, which would be sited at the Lansing Correctional Facility. We commissioned a feasibility study to determine if there was even any support in the community for a project like this. Our consultant did determine that there is quite a bit of support within the business community for this project, but the common theme we had heard back was they would expect the state to have a larger financial stake in this project, with that being 50% matching. So this is why we're pursuing this change in the statute. There will be no fiscal impact as a result of this bill. The legislature did appropriate last session the funding necessary to meet the 50% matching rate to draw down those private donations last session. So, and with that, Madam Chair, I'll stand for any questions.
Thank you. Are there any other persons wishing to testify as proponents on the bill? Not seeing any, then we'll go ahead and open it up for any questions. I have a question for you, just confirming that there's no fiscal note associated with this.
That's correct, Madam Chair. There is no fiscal impact. Again, the funding for the 50% match has already been appropriated to the department.
Thank you. Would this impact the Hutchison facility as well?
If this proves to be a successful venture and we're able to leverage those funds, build the career campus at Lansing, our next step would then be looking at what we can do at other facilities to do a similar project like this.
Thank you. And what are some of the private entities that are involved in the project?
We're not at a point right now to discuss who might potentially donate to that. We're at the very beginning stages of starting to ask for some of those commitments. We anticipate some of those asks will come forth here within the next month or two.
Thank you. Committee, other questions? Senator Klemp.
Thank you, Madam Chair. More of just a comment. I appreciate you bringing this forward. Especially at the Lansing Correctional Facility, I think the career campus, that would be a great location for that. So appreciate it.
Thank you.
Thank you. Any other questions? Not seeing any, then thank you for your testimony. Appreciate it. Is there anyone wishing to testify as neutral or opponent on the bill? Not seeing any, then we will close the hearing on the bill. Next, we will open the hearing on House Bill 2182. Prohibiting a sheriff from charging a fee for service of process for proceedings under the Protection from Abuse Act and the Protection from Stalking, Sexual Assault, or Human Trafficking Act. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2182 amends KSA 28110. This is the statute that establishes a fee that's charged by the sheriff for serving, executing, and returning any process. This bill adds an exception to the fee of $15 charged, which is the current law provision, and provides that no fee shall be charged for serving, executing, and returning any process for a proceeding pursuant to the Protection from Abuse Act, the Protection from Stalking, Sexual Assault, and Human Trafficking Act. And then the House Committee on Judiciary also added a provision that no fee shall be charged for that process for a proceeding that is similar based on the laws of another state or jurisdiction. And I can take any questions.
Thank you. Any questions? Not seeing any, thank you. And we will invite proponent conferee Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence. Please introduce yourself and welcome to committee.
Madam Chair, members of the committee, Michelle McCormick. I'm the Executive Director of the Kansas Coalition Against Sexual and Domestic Violence. Thank you for the opportunity to present some information to you this morning. You have my written testimony, so I'll just briefly summarize that we brought this request to the House because certainly it's our perspective that victims and survivors of domestic and sexual violence should have the least amount of barriers possible in order for them to get access to the tools that provide for their safety. And so while it is customary in our state that sheriff's offices do not charge a fee for protection order service, it isn't statutorily required. And so it has popped up occasionally where a new sheriff's office or someone comes in and they may try to charge that service fee. It usually has been addressed through relationships and advocacy. However, we've also learned that by not having it clear in statute that there shouldn't be a fee, that it can create some problems for our state to be eligible for the funds that are provided by the Department of Justice, the Stop Violence Against Women funding that's available to us. And so those are the primary reasons. We've worked with our collaborators at the Sheriff's Association and other folks in order to ensure this doesn't create problems. And with that, I'll stand for questions.
Thank you. Is there anyone else wishing to testify as proponent on the bill? Not seeing any, so I want to direct your attention, committee, to at your desk. You have proponent written only testimony from Ed Klump on behalf of the Kansas Sheriff's Association. With that, any questions? Senator Reichman.
Thank you very much, Madam Chair, and thank you for bringing this forward. I guess my question is, do you have any idea how often this does happen across our state or anything that's going on there? Is this a common occurrence? Thank you.
Thank you, Senator, for your question. Well, that isn't a metric that I'm aware is being tracked. I can tell you anecdotally it doesn't happen that frequently. Just occasionally in my experience of providing direct services, it's happened probably just a handful of times.
Thank you. Committee, other questions? Senator Klemp.
Thank you, Madam Chair. You had, and thank you, Ms. McCormick. So you had made a statement that we're potentially missing out on some potential grants as a result of not qualifying due to how that we may be taking a fee because this is not statutory.
Yeah, what I can share with you, Senator, thank you for that question. We did provide some additional supplemental information in our written testimony that basically says that our state has to certify that we meet criteria in order to be eligible for those STOP funds. And I believe that what the Department of Justice has flagged is that this part of that requirement has not been statutorily met. And so at this point in time, I believe we still have access to those funds, but they have flagged it that we are going to have difficulty continuing to meet that certification requirement if we don't make this change.
To add on to that, do you how much is that? Do you know how much funding that we receive?
I don't have that exact number for you. That's a fund that's distributed by the Kansas Governor's Grants Program, and they track that. And so we would need to get back with you with that information.
I was just curious. Thank you.
Thank you.
Thank you, Madam Chair.
Thank you. And how much is the service of process fee to serve these now?
Thank you for that question. Madam Chair, I'm not aware that there
I see.
has
I
been...
think it's $15. Usually, except if the bill became law, then it wouldn't be, the $15 wouldn't be charged for the service of process.
That's correct.
So, okay. And our fiscal note is including a statement that the judiciary indicates the enactment of the bill would have no fiscal effect on state revenues or expenditures. And the Association of Counties indicates the bill would decrease county government revenues, but a precise estimate couldn't be provided. Did we have any information? I mean, the judiciary doesn't serve these. It would be our law enforcement community who does. Did you have any input? I see we do have testimony from Mr. Klump on that they would be able, okay. And the Sheriff's Association has said that currently sheriffs indicated that they were not charging service fees on serving protection orders. So this just codifies what's already the common practice amongst our sheriffs in Kansas, and to get us in better position to make sure that the federal funds continue.
Yeah, Madam Chair, that's correct. That's my understanding. It's customary to not serve, or to not charge a victim for filing these protection orders. It just hasn't been statutorily clarified.
Great, understand then. Thank you. Are there other questions? Yes, Senator Corson.
Thanks, Madam Chair. And I'm asking you because we don't have any other oral proponents today, but this may be a research revisor question. The House amendment says, or a similar proceeding based on the laws of another jurisdiction. I'm just wondering how workable that is going to be. Like, would law enforcement readily know what would be considered a similar proceeding based on the laws of another jurisdiction, Oklahoma, Nebraska? So I just want to make sure that we're comfortable that it's workable. I don't really have an objection to the concept, but that House amendment jumped out at me. So I wanted to pose it for whomever maybe is best positioned to answer that. Thank you.
Thank you, Senator. I did want to note that Ed Klump from the Sheriff's Association is here, and they submitted written, but I think that he could provide some helpful information about how sheriff's offices receive that paperwork from other states in order to serve the out-of-state order. That might clarify that.
I'd appreciate that. I think the committee would as well. So yes, Mr. Klump, please introduce yourself and welcome to committee.
Turned it off instead of on. Ed Klump, representing the Kansas Sheriff's Association. So how this works is another state may have one of these protection orders, and they identify that the person that needs to be served is in the state of Kansas, and they'll send that order to a sheriff here in Kansas, and then we will serve that document for them. So putting this in the bill will not, of course, alleviate any fees the court may charge in another state, but it would certainly mean that we would serve that here without any process serving fee charged by our sheriffs, which is the common practice. When we surveyed our sheriffs, we didn't find any sheriff, I can't say absolutely no one is, but we didn't find any sheriff that currently charges this fee on protection orders.
Thank you. Committee, other questions? Not seeing any, then thank you for your willingness to come up and present some oral testimony. Appreciate it. Thank you. Are there any other persons wishing to, and you do have committee proponent written testimony from Ed Klump on behalf of the Kansas Sheriff's Association at your desk. Is there anyone else wishing to testify as neutral or opponent on the bill? Not seeing any, then we'll close the hearing on House Bill 2182. We're going to open the hearing on House Bill 2118, requiring any person who solicits a fee for filing or retrieving certain documents from the federal government, the state, a state agency, or a local government to give certain notices to consumers, and providing that violation of such requirements is a deceptive act or practice subject to penalties under the Kansas Consumer Protection Act. And with that, a bill brief from the revisor.
Thank you, Madam Chair. House Bill 2118 would enact a new section. Subsection A there specifies that the bill applies to any person other than the federal government, the state, a state agency, or a local government who solicits a fee for filing or retrieving a copy of a public record or certificate from such governmental entity. Those persons would be required to include in that solicitation a statement that the solicitation is an advertisement, not made by or on behalf of a governmental agency, and there's no requirement to take action. It'd also have to include the physical address and name of the person making the solicitation, information about how the consumer can file a document with the Secretary of State or obtain a copy of that certificate or a public record, and a statement that this is not a government document in large type on the envelope or outside cover of a mailed solicitation. Using a format or language that would make that document appear to be issued by the government or some legal entity would be prohibited. And as the chair mentioned, a violation of these requirements would constitute a deceptive act or practice pursuant to the Kansas Consumer Protection Act. The bill also defines the terms solicit and solicitation as direct advertisement and excludes communications initiated by the consumer or with a consumer with whom the solicitor has a current or former commercial relationship. And I can take any questions.
Thank you. Committee questions? Not seeing any, thank you. We're going to invite proponent conferee Clayton Barker, Deputy Secretary of State, General Counsel, Office of the Kansas Secretary of State. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Clay Barker, General Counsel, Kansas Secretary of State. The Secretary of State brings this bill on behalf of thousands of small, and I mean the really small Kansas entities that don't have their own trade organization or lobbyists. And given the number of complaints we received about this problem, we felt it was our duty to bring this to the legislature. What it combats is a common form of deceptive scam, and there's been warnings from everything from the Better Business Bureau, Federal Trade Commission, National Association of Secretaries of State, and many state attorney generals or secretary of states warning the small entities about this. And what it is these deceptive organizations will send out mailings or emailing, sometimes websites, implying they're a government organization or that the small company needs to file something with the government. It's not fraud, because if you read these communications carefully, they never actually say they're the government. They're just saying, pay us $300 and we'll do something that would normally cost $10. And some of the types of scam, and again, this goes to the small companies. There's 29,000 new LLCs formed in Kansas every year. Most of them only have one or two people involved with them. They don't have their own lawyers or in-house accountants to warn them about this. But some of the more common ones are the report requirement. You need to file a report with the state, pay us $400, we'll do it for you, when it really only costs maybe $50 or $80 for the entity to do it. A very common one we see in Kansas is you filed your new company, you need a certificate of good standing. Pay us $275 and we'll do it for you. One is an entity really doesn't need a certificate of good standing unless it's entering like a loan or some other transaction, and the person can do it for $10 on our website. Takes about a minute, and you get a certified document immediately sent to you. So what these entities are doing is wildly overcharging Kansas companies and for something that the company can do very easily by itself, and implying they need to do it when they don't. Sometimes you'll get a scam saying you need to file your annual minutes with the Secretary of State, and no, you don't, and if we get it, we wouldn't know what to do with it. And the common one that's come up, some of you may have heard, the federal requirement for beneficial ownership, the FinCEN, which is the on again, off again, on again, off again. I'm not sure if we're supposed to do it or not anymore, but it has nothing to do with the state. And we've even got a warning on our website about this, but people will mail out and say, pay us this money and we'll do your FinCEN filing with the state of Kansas. And first of all, it's free and it's supposed to be done on a federal website, but it's these types of deceptive measures that we're trying to combat. And the bill was described well. It just requires a disclaimer. It's not a crime. It would fall under the Consumer Protection Act, and the Attorney General had no concerns with this being added to it. So it would be civil actions and injunctions would be used to stop this, not a criminal charge. And it does not apply if there's a pre-existing relationship. So if your own attorney or accountant said, I need to file this for you, these disclaimers wouldn't apply. But it's just a warning to these entities that this is not a government request, you don't have to do it, and here's the people that it would be filed with to protect small Kansas companies from just wildly overpaying. And in fact, after we passed this in the House, it went through 117 to 2. Two representatives came up to me and confidentially told me that their businesses they had fallen for this scam. One was wondering why the fees had increased so much, and I told him it hadn't. You fell for the wrong thing. But they're very, very well done deceptions. If you don't read it carefully, you'd think, I better check the box. $300 isn't too much. And so, Madam Chair, I'll stand for questions, but we urge passage of this to protect the small businesses of Kansas. Thank you.
Thank you. Committee questions. Senator Bowser.
Thank you, Madam Chair, and thank you, Mr. Barker, for your testimony. I'm not very clear on how do you distinguish between Publishers Clearinghouse sweepstakes envelope and some other envelope that might need these words, this is not a government document. How do you distinguish the difference?
If the solicitation is going to a Kansas entity or it's being sent from Kansas, that's where we would have jurisdiction. If it's soliciting, it's asking to file something for you and giving a fee, that's what would trigger the need for the disclaimer. And the way it would be enforced is if a company got one of these and there was no disclaimer on it, we'd turn it over to the Attorney General and they'd decide whether it was worth following up.
So if it's not sent to an LLC, it wouldn't need these words on the envelope?
Only if the message that's going to the LLC or the company is, we're filing something for you. Either let us file it for you or you need to file it, pay us money, and we'll do it for you.
And how would the Secretary of State be notified? Is it a consumer complaint, or
we
how
get
would you?
Probably 10 a week of people complaining, like, why are your fees so high? What is this? I paid for this. Did I need to?
And then what action would you take? You're going to contact the soliciting company and say, you've got to put this on your envelope?
We would turn it over to the Attorney General.
Thank you.
Thank you. Senator Reichman.
Thank you very much, Madam Chair, and thank you for bringing this forward. I think maybe you already answered this by the previous question. Looking at the bill a little bit, it says, so the people that are contacting and trying to solicit this money and so on and so forth. So this bill, if they're going to contact people, they have to list this certain information that, you know, who they are and all that kind of stuff. So you're thinking that's going to pretty well clear up most of the stuff we're going to people?
Senator, I probably should have added this to my testimony. We took this idea from many other states, have come up with, this is probably the best solution state government can do. It doesn't interfere with business, but it just requires a disclaimer for these sort of cold calls or cold solicitations. So a lot of this language came from other states, and our revisor improved on it. And those other states have seen a decrease in this type of deception. It doesn't eliminate it, but it helps combat it.
Okay. So as I've been a business person, if I got one that wasn't right, I would just kind of turn it over to you, and then you would turn it over to the Attorney General, or how?
Correct, Senator. We inform the customer, don't pay this, or if you did, try to get your credit card charge back. And we turn it over to the Attorney General. We'd ask them, the customer, to send us a copy of whatever letter or solicitation they received, so that would be evidence for the Attorney General to work with.
I see that there's figure it's going to be another, they're going to put another $78,000 on the state for doing this, and they're going to need another investigator. So does that make sense to you?
I'm sorry, Senator, I couldn't hear.
It says the office would require $78,075 from the state general fund for salary and wages, and add one investigator. Does that make sense to you that we need this? Thank you.
That sounds logical, Senator, but I don't have a lot of background to know for sure.
Thank you. Committee, other questions? I have a question. You said that this would apply to solicitations made to primarily LLCs and smaller businesses across the state, or who are these solicitations being made to mostly that your office is aware of?
Senator, the complaints we get come from the very small entities, which are almost always LLCs. And a lot of it is they form up, and then immediately they get a subscription service to records in Kansas. These are all public records. And then they'll immediately contact the new entity and say, you formed, now you need a certificate of good standing, or let us help you file these mandatory government reports that may or may not be correct. And then we hear I assume the sophisticated companies sophisticated is probably not the right word, the larger companies that can have their own lawyers and accountants protect them either may not get these solicitations or they just throw them in the trash. It's the smaller ones that seem to think this sounds legitimate. I've heard these words before, and they make the payment when they don't need to.
Thank you. So this wouldn't cover if it comes to my home and I'm not an LLC or an incorporated entity, but I receive this solicitation. It would cover that instance if it comes to a person, right?
Well, Senator, what they're trying to sell is you need to file
The
something
filing
with the government.
fees for the businesses.
I guess if you were a sole practitioner, they could send that to you. Sole practitioners don't file in Kansas, but they could try to pretend you're supposed to, but they'd have to know you're a business. It wouldn't really make sense for an individual.
So my question is, this falls in the Consumer Protection Act, and the bill talks at line 25 on page 1, information on where the consumer can file a document directly. And the Consumer Protection Act doesn't include business entities as a consumer. Consumer means, I'm reading in the, and correct me if I'm not looking at this correctly, consumer means an individual, husband and wife, sole proprietor, or family partnership who seeks or acquires property or services for personal, family, household, business, or agricultural purposes. So our LLCs wouldn't fall into this bill because they're not consumers in the Consumer Protection Act. So do we need to expand the definition of who this applies to? It applies to LLCs or others required to file with the Secretary of State or something? And maybe the revisor can help me, but I don't see that this would apply to LLCs who received this solicitation.
Madam Chair, I would need to do a little bit of research. I am familiar that we do have some instances where we make something a deceptive act in practice under the Kansas Consumer Protection Act, and then we add another provision that we deem them a consumer and we deem so-and-so a supplier for purposes of interpreting the act. So it's possible we could maybe add something there, but let me do a little bit of research on the definitions. And
yeah, I would think we would need to talk more fully, not just consumers as defined in the Consumer Protection Act, but the LLCs and the entities you're talking about intending to be protected.
Madam Chair, I don't have the Consumer Protection Act in front of me. I did look at it when we were working on the bill, and I remember being satisfied that it would fall within some of the definitions. I'd have to go back and look, though, to see what I was looking at.
Okay, well, yeah, I would like some further clarification on that because as I'm reading it, it says on page 2, line 1, a violation of this section shall constitute a deceptive act or practice as provided in 50-626 and amendments there too. So, and like I said, I just read that definition of consumer, so perhaps an amendment to help include the LLCs if we need to do that, or maybe it's included somewhere else. Yes, Ms. Scott.
Madam Chair, and this could be what Clay was referring to. I'm trying to decide if it really is included. So as you read, the definition of a consumer means an individual, husband or wife, sole proprietor, et cetera. And then there's a definition of person, which means any individual, corporation, government. So those folks are included, but the term person isn't used in the definition of consumer. Only individual is used there. So I might, run it by a few of the other attorneys in my office and see what we can, if we think it's covered or not, and come back.
Right, because the bill only, when the bill talks about person, the bill references the person doing the soliciting. It doesn't say a person who receives the solicitation. So maybe that would be something to look at as well if if the Secretary of State would be amenable to some amendment that we could help clarify if we need to.
Yes, Madam Chair, of course, in an odd way, this doesn't affect our office because we get paid whether it's the scammer or the real entity, but we're trying to help the companies. We'd be open to any amendment to make it clear.
With the intent, right, if we want to execute the intent of the bill. So, well, thank you for the conversation about the issue, and we'll look at it a little further to make sure it covers the LLCs and other entities who are receiving these solicitations. Any other questions? Not seeing any, then I don't recall. Oh, yes, Senator Bowers.
Thank you, Madam Chair. And hi, Clay, nice to see you. And in fact, my last LLC that we formed, I did receive this letter, $275 to order a certificate, but it wasn't quite government print font. It looked different to me, and that's when I brought it to your office's attention. So it came within 2 weeks of filing with your office. Where did they get, they go online and look at the new LLCs that are filed? Is that where they have, it's open records that they could go onto your website and find? Like I was brand new, fresh, but I didn't take the bait. So thank you, Clay, and thank you, Madam Chair.
Senator, it's all public record. When you file with us electronically, it's instantaneous that it's available. The way an entity could figure out who's the new LLCs, you can either order a report from us through the Open Records Act, or I believe there's a subscription service from KIC that can give you updates constantly of different business filings, although you're supposed to sign an agreement that won't be used for commercial purposes. So we don't get many of the Open Records Acts for every new LLC in the last week, but you could.
Thank you. Any other questions? Not seeing any. Then thank you for bringing this to the legislature and bringing it to our attention. Appreciate it. Thanks for your testimony, too.
Thank you, Madam Chair.
Thank you. Is there anyone wishing to testify as neutral or opponent on the bill? Not seeing any, then we will close the hearing on House Bill 2118. Committee, we have a few minutes, and I would like to work potentially final action on two bills. The first would be House Bill 2312. And 2312 is something that we heard Monday this week, and it's excluding certain offenders convicted of a non-person felony from participation in certified drug abuse treatment programs. And with that, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2312 was the bill from the Sentencing Commission related to the Senate Bill 123 program, excluding those offenders who are subject to a special rule, and then allowing community corrections to do the risk and needs assessment for those offenders.
Thank you. Any questions for the reviser? Not seeing any. Any discussion? I do have a conceptual amendment I'd like the committee to consider, and that is to change the date of the effect of the statute from publication in the statute book to the Kansas Register. And I think we're all familiar with that kind of amendment, and we have a second from Senator Clays. Any questions or discussion on the amendment? Then I'll close, and you all have heard the motion. All those in favor signify by saying aye. Aye. All opposed, no. The motion carries. We're back on the bill as amended. Any further discussion or a motion? Senator Haley.
Thank you, Madam Chair. I move we adopt or that we report this bill favorably as amended.
Thank you. Is there a second? Senator Bowser, any discussion? Not seeing any. Then did you want to close, Senator?
I close.
Thank you. All those in favor signify by saying aye. Aye. All those opposed, no. The motion carries. Thank you. The other one I wanted to look at was a bill we heard yesterday, 2359, regarding enacting the Uniform Guardianship and Protective Proceedings Jurisdiction Act and the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. And with that, a brief reminder from the reviser.
Thank you, Madam Chair. This is the bill from that Judicial Council Working Group replacing our current guardianship laws with, for the most part, what would be the Uniform Adult Guardianship and Protective Proceedings Act. And then it also adopts the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act.
Thank you. Committee, any questions for the reviser? Any discussion? Senator Bowser.
Thank you, Madam Chair. I just support this bill. Long time ago, I served in the military, and I actually encountered someone who ran into this issue, and I know we had some testimony from DOD on it. I stand in support of the bill. Thank you.
Thank you. Committee, any other discussion? Not seeing any. We did consider changing the date on this, but I think it's something that we just want to pass out as is, if that's possible, and if that's the will of the committee. So with that, is there a motion regarding the bill? Senator Titus.
Thank you, Madam Chair. I move that the committee recommend favorably for passage House Bill 2359.
Thank you. And a second from Senator Rose. Any discussion? Not seeing any, then do you want to close?
Close.
Thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The motion carries. Well, thank you, committee. Please make sure that if you do have amendments, you're getting those ready. There are some other bills that we have heard that could potentially be worked, so make sure you have your amendments in with our reviser, and so we can have those ready for potential working. But with that, I want to thank committee and staff and our conferees and those in the committee meeting room and following along online. With that, the meeting is adjourned.